So this decision, I want to digest it, but it's a sick feeling in my stomach to think what we have to do to put the Constitution back together.
This is the voice of democracy, open, free to all. God bless you. God bless America. Thank God that the Supreme Court followed the Constitution.
There's only one way to truly fix Obamacare, only one way, and that's a full repeal.
This is a good day for the American people. They won today. It's also a good day for the rule of law.
The court makes a decision about whether this law is constitutional. It doesn't mean that the law is wise. It doesn't mean that the law is good for the country.
Just a sampling of some of the reactions to the Supreme Court's decision last week, obviously upholding Obamacare, and it ran the gamut. Now, depending on what side of the aisle you were on, well, the decision either meant despair or joy, but it is safe to say that while the initial reaction for conservatives was that the sky was falling, it has changed as the news has had time to not only sink in, but people have actually digested the entire opinion. Take a look at what George Will, certainly one of, if not the conservative columnist, wrote soon thereafter. Conservatives want a substantial victory on Thursday. The physics of American politics, actions provoking reaction, continues to move the crucial debate about the nature of the American regime towards conservatism. Chief Justice John Roberts Jr., he went on to say, has served this cause. The healthcare legislation's expansion of the federal government's purview has improved our civic health by rekindling interest in what this expansion threatens, the framers designed for limited government. And as Charles Freed, a constitutional law professor at Harvard and Solicitor General under President Reagan, was quoted as saying, the limitation of the Commerce Clause is a complete capitulation to the bogus logic of the broccoli argument and its proponents in the Tea Party. And you got more coming. As SCOTUS Blog's Lyle Denniston said, the rejection of the Commerce Clause should be understood as a major blow to Congress's authority to pass social welfare laws. So, Roberts' decision, depending on who you talk to, was either a master stroke here in a roundabout way to chip away at the power of the Commerce Clause and ergo the role and power of the legislative branch in Washington. And joining us now to explain, Mark Furnish, criminal defense attorney, professor of Brooklyn Law, and he's argued, as we said, before the Supreme Court, helped us out in a huge way last week, has been named one of New York Metro area's super lawyer, and I think the most impressive line, other than just becoming a grandfather, congratulations, is that you were the only guy I know who called it 5-4 before, with Roberts being the swing vote to go with the liberal justices, and we have audio tape record of him actually calling that. I thought you were crazy when you first said it, but anyway.
Well, broken clock, you know.
Now explain, you've read all the opinions here. Are they on to something?
No, they're not on to anything at all. I mean, that's purely wishful thinking. It's all true about the Commerce Clause, what they say, but, I mean, as I've said from the get-go, result trumps reasoning in this case. He went as far as he could go with the Republicans, and he dealt them a major blow by upholding it.
So the distinction for the audience, and as much as you can put this in lay speak, between the tax and what they're calling this or not a tax, what does it really mean as it relates to precedent and going forward for authority for the government?
It doesn't mean much of anything because this is what we call in the law sui generis, unique. I don't think that Congress is going to be trying to push the envelope with any piece of social welfare legislation as far as they did here with health care. 6 consecutive administrations or something like that have tried to get this thing passed, so it ended up being passed by default under the tax rationale. How many times do you think that Congress is going to overtly act under its tax power, given the fact that tax is the most toxic word in America's political culture? This was a salvage operation consistent with the principles of constitutional law because you're supposed to uphold a statute under any reasoning or rationale that's fairly possible. That's what Roberts did, consistent with the great traditions of American constitutional law. The Commerce Clause has been eroded pretty significantly over the past 15 years anyway. This just continues that trend. And really, I don't see it as having terribly great precedential impact. Much like Bush versus Gore.
You've got West Wing fans here at the table here, so we always love a good conspiracy theory. But many people not only opined, but even said, when you read some of the opinions that were written, they referenced Justice Ginsburg here. And they said, hey, the consequence, the rationale could be that Robert switched his position. He changed his mind.
I think he did switch. And I switched as well, and you know what caused me to switch? And I bet this is just pure supposition on my part. Reading polls in the New York Times that said the court's credibility was in the toilet, that 40% of Americans, or some very small percentage of Americans approved of the way it was doing its job, that struck me as really a bad thing for the United States of America, and it caused me to change my view as to how the case would turn out. And I'm just a regular person, and John Roberts, a much, much brighter individual than I am, at bottom is a regular person. It's a bad thing when people in this country can't trust the court, and I'm betting that's what caused him to flip.
I think it's a pretty good analysis. They came to the right ruling for the wrong reasons. It's not a tax, and it is within the commerce powers of the Congress, but he could not get majorities for those propositions. So he went with 4 conservative justices on the Commerce Clause, and then a different set of 4 on the tax kind of thing, and crafted a result. In the long run, the ability of the Congress to function in an economy dominated by large corporations will require an expansive reading of the Commerce Clause. In the long run, the use of the taxing power for this kind of thing is bizarre. Suppose the Congress passed a law saying every American had to buy a gun, or else he or she would have to pay a tax. You'd get a very much more different result. Good result, bad reasoning. Let's move on.
A couple quick things. One thing that always struck me, Dominic, is we know how much no one can keep a secret, especially in the world of politics. 30 people knew this result for a couple months, and they kept their mouth shut. Not one leak, if we were only so fortunate.
Well, Justice Ginsburg leaked it because she said in a speech that it had been a very taxing term for the Supreme Court.
Well, none of us knew.
Right.
We're used to leaks where people blab and they just put their name
You
on.
really want to mess with somebody with a lifetime appointment? I mean, there's decades of getting back at you from the bench if you want to keep doing that.
Well, here's part of the problem is we're getting caught up in the mixture of the politics,
Correct.
the opinion, and what matters. All right, the term is dicta, so the minor opinion and the statements made by Roberts, by the way, are not holding when it comes to trial judges, and this is where this comes.
Well, which part do you think is dicta?
Okay, dicta was his statements about the Commerce Clause. Here's what matters.
Here's what he said.
No, here's what he said. Well, let me finish what he said. He said it may reasonably be read as a tax. The Constitution permits such a tax. However, the only opinion binding in this entire decision is the tax argument, which is Congress's ability to bind. So all the other statements he makes that everybody wants to spin as political calculus are not binding. When it comes to trial judges, they're looking at how it sets precedent. And we can't get lost in
the Commerce is precedent because the 4 dissenting justices agree with Roberts' view, and which, by the way, that view is entirely consistent with what the conservatives have been doing to the Commerce Clause, I think properly, since 1995. So this is nothing new, and his Commerce Clause opinion will have tremendous resonance in the areas of crime control and public welfare legislation.
Well, general welfare, and I'll go back.
I got to rep, but before I let you go, Grandpa.
See the gray?
You think when historians, and they will, and they'll look back at this case, do you think that they'll ascribe a certain brilliance to Roberts at this time, in this age, in this politically partisan climate that we're in right now, or will they say the guy basically made it up as he went along?
No, I think they'll find it brilliant. And we started to touch on this the other day, and I wrote about it subsequently, that it was Machiavellian, if not Solomonic. Look what he did in one fell swoop. He rebuilt the public trust in the court, insulated it from charges of politicking, burnished his legacy, curbed Congress's commerce power, which is a favorite pet conservative project, and managed to saddle Obama with the stigma of a backdoor tax in an election year. What could be shrewder than that?
Absolutely wrong. He did not restrict Congress's power to regulate commerce in this decision. No, he didn't.
And just
he absolutely
at the opposite,
no,
we might have had some consensus. That brought me back to reality. Thank you both.